Welcome to USA Justice Hub.
Docket 25516 FC, People of the State of Michigan versus Siobhan Hanks. Counsel, your appearances for the record.
Good afternoon, Nicole Matusco on behalf of the people.
Good afternoon, Your Honor. Jacob Starks, the fourth Assistant Public Defender, here on behalf of Mr. Hanks. He's present at the podium. He's standing to my right.
Sir, please raise your right hand.
Chaos in the Michigan courtroom. Threatening letters, anger, and a defendant on edge. One man's own words and now the weight pulling him down. Will his outburst cost him his freedom before the trial even
Sir, please
begins?
raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. This is a motion to reduce bond. Is that correct?
That's right, Jen.
That's correct, Your Honor.
Prior to this, sir, however, you seem like such a nice young man. I've read your history. It's not the worst, but you have a few things that are not so nice as well. What is troubling to me, before we even get to this motion, is that I do not let anyone, and I mean anyone, disrespect a public defender, disrespect a prosecutor, law enforcement, or anyone in my office. I have a staff of letters that you have written to our prosecutor, who does an outstanding job. I want to read some of it to remind you of the disrespect that you have shown. Here's a letter that starts out, "Hey, bitch Matusco, it is Siobhan Hanks writing you again. This case has been going on for over 13 months now, and still not a plea deal been offered to me." It goes on. Here's another letter. "Hey, bitch Matusco, this is Siobhan Hanks writing your bitch ass again. Still no motherfucking resolution. Huh, bitch? It is not hard for you to figure the fuck out what you want to do with me, bitch Matusco. This case is petty as fuck. This case is so fucking frivolous, okay? Yes, I know I did something wrong, but this is not some type of big case. This is not an average armed robbery. All I did was use a punk-ass BB gun to take a punk-ass dab pen and a punk-ass breeze while I was high on multiple different drugs. Bitch, stop playing and give me rehab with probation. Do not even offer me any prison time because I am not taking it. So with that being said, bitch Matusco, I need some type of plea deal with no more upfront jail time immediately." Goes on to talk about other things about the plea deal, and then said, "I did shit to people who did less than what you are doing. So fat funky bitch, hurry the fuck up. It is time we wrap this case up. And when you bring these letters up in court, mention my reason for them. Oh yeah, I do not give a fuck about you reading these letters in court. Go ahead, I want you to. No fucks is giving." Oh, it doesn't stop there. Do not know why the fuck you have not dropped my charge down to unarmed robbery or larceny from the person I truly did learn my lesson. Nobody got assaulted. I was high on a few different drugs at the time of the incident. I only did that for a breeze and dab pen. I clearly have a drug problem. I have over a year of jail time served. I am open to accepting rehab and intense probation, bitch. Again, more vulgarity. I do not give a fuck about you telling the judge about these letters. The fuck, you can show her shit. You can read this shit in courtroom for all I care, or give me all letters I wrote you, and I will read them in court with a big smile. I don't see you smiling now, sir. And I suggest you don't, because this isn't very funny. I am not scared of you, nor the rest of them crooked bitch-ass prosecutors that work at your office, including y'all master, John Dwayne. Oops, let me check myself. I mean, bitch Dwayne, y'all can suck the cum out of my big black dick. Fuck every business building on Kalamazoo Street, along with the whole Michigan Avenue bitch you trying to send me to prison over a BB gun, breeze, and dab pen. The victim was not assaulted. That shit is not worth any prison time. And it goes on. You owe the prosecutor an apology. You will not write these letters. You do not have the right to assault verbally the prosecutor or your attorney or anyone in this courthouse. None of us are in handcuffs. You are. You need to check your attitude and think kindness. These words are fighting words. They're assaultive and very disrespectful. Let me remind you, these are not small charges. And I don't even have a police report, but I'm looking at these charges. Count 1, armed robbery, is a felony punishable by life or any term of years. Count 2, weapons, dangerous weapon, carrying with unlawful intent, felony, 5 years or $2,500. Count 3, weapons, felony, firearm, pneumatic gun. And I don't have what that, just apparently doesn't have what that is. Is that a 2-year?
Your Honor, it's a mandatory 2-year consecutive to the underlying offense.
That part's missing in here. But anyways, I thought it was a 2-year. It's a 2-year. These are some pretty big charges. And it is only a small man who uses those words against a woman or against anyone. Those words do not make you strong, they make you weak. And it's very disappointing, sir. You have a mother?
Yes, I do.
You love your mother?
Yes.
How would you like it if somebody wrote those words to your mother?
I would not. I wouldn't like it.
Then what were you thinking?
I was angry. Case been at a standstill for a year and a half. I know it's not a good excuse, a good reason of why I did it, but I just been in a dark space mentally, just ready to get on with my life. I learned a big lesson since being locked up. Just ready for a resolution.
Sir, I'm here every day. Law enforcement, even on vacation, will call me. The jail will call me 24/7. I'm not unknown. Your attorney in his office is not unknown, and neither is the prosecutor's office. If you had a problem, you tell the sheriff. The sheriff's going to call us, one of us, all of us, and we're going to help you. These letters hurt your case. If you think that I am going to entertain a bond after I read those angry words, those fighting words, the answer is no. So y'all can make your record, but when I look at this, I look at danger, I look at threats, a lot of anger. We're going to get this resolved. I don't know what's going on here. I think we've had a few pretrials, haven't we?
We have a final pretrial and a trial date set. We have our final pretrial set for mid-March, Your
I think
Honor.
it's March 11th, Your Honor, we have a final pretrial with a trial date in April.
So shall we have the final pretrial? And in regard to these letters, I'm thinking maybe we have contempt. These are threatening. Contempt carries with it 93 days and or $7,500.
Well, Your Honor, we are still attempting to negotiate a plea offer here. I would simply respectfully request that we keep that window open until that March 11th date. It's my understanding that Madam Prosecutor would like to meet with the complaining witness again and then extend a final offer. We have been negotiating in good faith on both sides. Certainly, Mr. Hanks' alleged statements here have added another layer of complexity here to the negotiations, to put it mildly, understated. But respectfully, Your Honor, we are making every effort. I'm making every effort on my end. So is Chief Deputy Matusco, to try to see if we can find some common ground here to resolution before a potential trial date, which we have set. And I will be prepared and able to proceed with the trial on that date if needed, Your Honor.
Ms. Matusco, are you asking for contempt?
Your Honor, this time I would be asking the bond be revoked. We are set at $250. I believe the court rule allows it. The court did not read into the record the final statement on the final letter that I did receive in January. And that was—
Which one is that?
I don't know if yours are in the same order, but it says, P.S. I did a lot of bad shit to people who did less than what you are doing to me right now. Bitch, you better be safe. That ain't no threat either. That's a direct threat to
That is a
the
direct threat.
prosecutor here. It's not that we're using angry words. It is that we are literally threatening. And this has been Mr. Hank's consistent MO whenever he doesn't get his way. So rather than asking the court for contempt, it is my intention when I make my record as to the conditions for pretrial release to ask this court to simply revoke bond. So there's no way he gets out prior to that trial date.
I don't know how I missed that. I was just so appalled reading all of it, but it is also in capital letters, what you just read. P.S. I did a lot of bad shit to people who did less than what you're doing to me right now. Bitch, you better be safe. That's all capital letters. Capital letters means anger and is threatening. Under it, it says that ain't no threat either, meaning it's gonna be a real issue, is how I read that. Like you're gonna make good on it, not a threat. Bond is revoked. Any more letters, bad behavior, every single letter, every single bad behavior will be in 93 days. Contempt. Consider this a huge warning. Sir, you can't treat people like that. I don't know what anger issues you got, but we're gonna get you some treatment, mental health treatment in jail. Because if you continue this path, you're gonna be in prison. You're not doing yourself any favors, you're not keeping our community safe. Your anger is getting the best of you. You've been in front of me before, you've always been respectful. So I don't know what's hard. I am sure that it's very difficult being young and in jail. But you see, we have a retail fraud. Height was revoked. You have defrauding an innkeeper. You have CSC fourth degree by force or coercion. We have, do we have a pending charge? We have 2 files.
Your Honor, the pending charge was when he was out on tether. He cut his tether and was found in possession of cocaine. So the pending charge is having cocaine in his pocket.
So you got drugs, and you've already acknowledged in here that you were high and not making the best decisions. So you gotta address these issues, and we're gonna have that happen in jail right now. Is there a final offer, or are you still working on that?
Your Honor, it's my intention to meet with the victim in this matter. We've been working around work schedules and my own personal schedule within the next week, so that I will convey that final offer.
I have a final pretrial was last September, so I don't know what happened, but I know there's been a lot of changes and other things that have happened, so.
So I can address that.
Okay,
Previously, this case was being handled by Dale Caldwriter from my office, who was the assigned prosecutor in this case. Mr. Hanks made the decision to write him letters as well. So when I was covering this court, I took this case over to remove Mr. Caldwriter from the file to hopefully stop those letters from happening. Those are not attached to this motion, as I only wanted to update the court as to what has transpired since the last time this court denied bonds. And it's clear that the letters were getting more threatening once they were directed towards me. So I took this case over in September. Mr. Sartz and I began negotiating, exchanging information, mitigating information, discovery, to see if we could get a resolution in this case. So that's why that final pretrial was adjourned back in September.
all right, March 11th, final pretrial, you're here,
Yes, Your Honor.
and then when is the trial?
It's April 24th.
Probably 4 or 5 scheduled that we did, and I think a couple of them are older than this, so we need a couple backup dates unless you want to prioritize this because he's in lockup.
I will work with Mr. Buxton to see where we are on the list and then communicate that to Mr. Sartz as well. If a backup date is necessary, Mr. Sartz and I can work the schedule to get one.
You're remanded to the jail, you're gonna work with community mental health, see medical, psychological, go to CATS, get some treatment over there, sir. This cannot continue. I know you don't like jail, but you gotta change what you're doing out in society, or you're gonna be in jail, and then you're gonna be in prison. And this has not made me happy to do this to you, but I don't know what else to do. We have public safety. And I am fearful if I were to let you out again, it would get worse. So go into jail and work on what you need to work on. And there'll be no more letters like this. Otherwise, it's 93 days, every single letter. And that does not count against any other sentence. That is separate crime. Have I made myself clear?
Yes.
Do you have any questions about what I mean?
No, I understand.
Is there anything that you need over in the jail that you're not getting?
No, can't think of anything.
Quickest way to get out of jail is to behave. Start working on your rehabilitation. Talk to your attorney. Don't be rude, crude, angry. We didn't commit the crime. You're innocent until proven guilty beyond a reasonable doubt, but for bond conditions, I have to look at public safety. What I see here is not safe. You're entitled to your trial and you're gonna get one. But I also want you to consider these letters that you admitted bad behavior, criminal behavior. So I don't know how that's gonna play in, but you didn't do yourself any favors, sir. You said who you were, you wrote these, and you talked about what you did. Those statements can all come in at trial. But any pretrial notion about motions that this isn't gonna come in, set it in front of me, but I don't know how you get around this from coming in if people wanna bring it in. You can talk about that with your client, you need to talk about that with your attorney. Have I made myself clear, sir?
Yes, you have.
Very good. Is there anything else we need to address?
Yes, Your Honor. I believe we addressed it at the December court hearing. The no contact order for witness or for co-defendant. I know Mr. Starks and I have worked to get her an attorney appointed because some of the letters implicate her as well. I just want the court to reaffirm that no contact order and make it clear to Mr. Hanks that that includes reaching out by way of a third party. He recently made phone calls to a third party to make contact. That third party did cut him off, would not engage in much of a conversation, but I just want to make it clear that any contact, whether directly or indirectly with Ms. Hill, would violate this court's order.
Do you understand the no contact order? And Ms. Hill was already added. I have a note here, a potential witness, and she may have some culpability. We need competent counsel for her.
And she may have some culpability.
And we need competent counsel for her. So I don't know if that's occurred. It should have. This is my notes from last year.
It has, Your Honor. I believe the public defender's office was quick to provide her with competent counsel.
Sir, no contact with any witness, defendant, victim. You're not doing yourself any favors. Taking all your anger out on yourself. The only one you're hurting is yourself. Stop doing that. Help your attorney provide a defense. That's your job.
And Your Honor, that would include third-party communication or handwritten letters that I will note for the record are scanned by the jail.
Are you gonna have trouble not complying? Are you gonna have trouble complying, I should say?
No.
You understand no communication through third party? You understand what that means?
Yes, I do.
No contact means you don't exist in your world. No carrier pigeon, no smoke signal. No Hallmark cards. No letters, phone calls, email, text. Contact through third parties. They don't exist in your world. Have I been clear, counsel?
Yes, Your Honor. Thank you.
Any questions?
No.
That's all for the record. Thank you.
Thank you, Your Honor.
Anger and threats don't erase mistakes. They magnify them. Respect, patience, and accountability aren't optional in court. Behavior has consequences, and every action echoes back.